And welcome to OGE's Transition Readiness series. I'm Cheryl Kane Piasecki, and I'm very pleased to be joined today by Monica Ashar, who is an attorney in our Ethics Law and Policy branch. Welcome, Monica, to the broadcast.
Thank you, Cheryl.
Today Monica's going to be talking to us about the criminal statute 18 U.S.C. Section 203, which is, she'll be giving us a lot more detail about it, but kind of in a nutshell, is sort of a compensation bar for compensation that is in exchange for provision of representational services. And it's a lot more complicated than that. And Monica's going to give us a really good rundown on what that's all about. But one thing I did want to sort of make sure that it's clear to folks from the get-go. You may be asking yourself, why is this particularly transition readiness related? And I think, again, Monica's going to touch on this in a lot more detail in a moment, but the 203 is something that we do encounter when we're onboarding people who are outside of government coming into government, particularly people coming in from things like law firms and that sort of thing. And there's also a very squirrely little post-employment provision that is in 203 as well, and Monica's gonna steer us through that as well. So without further ado, Monica, it is your show, so please take it away.
Thank you. So as Cheryl said, I'm going to be discussing 18 U.S.C. 203, which is a criminal conflict of interest statute that concerns the receipt of compensation in matters affecting the government. And the first couple of times that I presented on 203, I did so in connection with a presentation on 205. And when you look at 203 and 205 side by side, you notice several similarities. One key similarity being that they both deal with representational activity, and sometimes it can be tempting to somehow conflate the two. But the big difference here with Section 203, as you're going to find out, is compensation. So I want you to keep this word in mind as I go through the presentation, particularly the first part. And just to give you a sense of where I'm going, I want to start with a quick overview of the structure of Section 203. So in particular, this presentation is going to focus on 203A1B, which deals with employees of the executive branch. So the restrictions in 203A1 apply to all executive branch employees and all employees of the legislative and judicial branches. They also apply to elected members of Congress. I'm also going to discuss the application of Section 203 to special government employees. And then I'm going to conclude by briefly noting some of the exceptions.
For those on the phone, Monica was just going through slide 3, so just so that everybody is aware of where we are in the slide presentation.
So I've put up on the screen the elements of, actually this is slide 3, just so everyone can follow along. And I put up on the screen the elements of Section 203A1B. And I'm going to take a moment to briefly go through them. And there are, if you're watching on the screen, there are quite a few of them. So Section 203A1B is a prohibition on, other than in the proper discharge of one's official duties, directly or indirectly, receiving, accepting, seeking, demanding, or agreeing to receive or accept compensation in exchange for the provision of representational services as agent or attorney or otherwise to a third party, rendered or to be rendered either personally or by another, at a time when such person is an employee. And this is in relation to a particular matter in which the U.S. is a party or has a direct and substantial interest before a department, agency, court, court-martial, or any civil, military, or naval commission. Whew, okay. So as you can see, there are quite a few elements, but I want you to notice a couple of things. The first thing that you'll probably notice is that a number of these elements are familiar and can be found, for example, in 18 U.S.C. 205, 207, and 208. So for the first part of my presentation, I'm going to focus on those elements that are probably more familiar, the ones that you probably know already. And second, I want you to notice the 3 elements that have little graphics by them, not only because I enjoy making little graphics, but it's so true, but because I want you to remember them, especially in the first part of the presentation. Because when you think about Section 203, I want you to remember, I want you to think about compensation in exchange for the provision of representational services at a time when the person is an employee. And I'm going to begin by discussing representational services. So Section 203 uses the term representational services as agents or attorney or otherwise. And there's a similar prohibition in 18 U.S.C. 205A2 on acting as an agent or attorney. However, the term is not defined in the statute. So when we say representational services, what do we mean by this? So first, it means that there is a communication to or an appearance before the federal entity. So if the employee is merely providing behind-the-scenes advice, there would be no communication or appearance. And second, the term representational services requires the intent to influence. So the communication must be in connection with some matter on which there is some controversy, or at least a potential for divergent views. And so this would be in contrast to routine factual statements where it's really highly unlikely that there would be any controversy. And OGE discusses this intent to influence in depth in its advisory 07X12. So as I mentioned earlier, 18 U.S.C. 205A2 contains the language acts as agent or attorney. So Section 203 is at least arguably broader in terms of the types of representational activity that's prohibited. Section 203 again covers any representational services as agent or attorney or otherwise. And at least one federal court has said in dicta that Section 203 might cover representational services that do not amount to acting as someone's agent, at least within the common law meaning of agency. So going back to our element slide, and this is slide 6, Section 203 pertains to representational services in relation to particular matters. And if you look at the language that Section 203 uses, you'll notice that it's probably very familiar. Cheryl, where have we seen this language before?
Oh, that looks very much like something I've seen in the 18 U.S.C. Section 208 conflicting financial interest law.
Exactly. So Section 208A uses virtually identical language. So the good news, the very good news, is that you can apply what you already know about the meaning of particular matter from Section 208 to Section 203. And so with Section 203, we're concerned with particular matters involving specific parties, as well as particular matters of general applicability. Again, particular matters do not include the consideration or adoption of broad policy options directed to the interests of a very large, very diverse group of persons. These would simply be matters, not particular matters.
Monica, can I just ask a clarifying sort of question here or make a statement and by way of clarification is, while for purposes of 208, the distinction between the two different types of particular matters is material for purposes of the application of the exemptions and other reasons, there's no reason necessarily to distinguish between the two types of particular matters for purposes of 203, is there?
When you get to special government employees,
okay.
You'll see where we have the distinction. But for now, we're just concerned with particular matters, regardless of whether it's a particular matter of general applicability or a particular matter involving specific parties.
Okay.
So in addition, there has to be a nexus between the U.S. and the particular matter at issue. So moving on to the next element, the U.S. must either be a party or have a direct and substantial interest. And in many cases, it will be clear whether this is or is not the case. But what if it's not so clear? What does it mean for the U.S. to have a direct and substantial interest in the matter? So there's no statutory definition of the phrase direct and substantial as used in Section 203, but the phrase does appear in other criminal conflict of interest statutes, notably 18 U.S.C. Sections 205 and 207. And OGE's regulations interpreting Section 207 provide helpful guidance on the scope of the phrase by describing its application in the context of that statute. So when you're looking at a Section 203 issue, if you think it's likely that a particular government component could either be a party or have a direct and substantial interest, you're going to need to coordinate with the ethics official at that relevant component. The component is then going to make a determination as to whether it has a direct and substantial interest, taking into consideration several factors, which I've provided here. And these factors are listed in 5 CFR 2641, which again implements 18 U.S.C. 207. And keep in mind that although a federal statute might be at issue or a federal court might be serving as the forum, this doesn't necessarily mean that the U.S. is a party or that it has a direct and substantial interest in a particular matter. On the other hand, the matter might be pending in a non-federal forum. Regardless, the U.S. may be a party or have a direct and substantial interest. Additionally, you're going to have to consider whether any government component is a party or has a direct and substantial interest. And you're going to need to be careful here because even if it is determined that the U.S. does not have a direct and substantial interest at the present time, such an interest may arise while the matter proceeds, which would then trigger the statutory bar. So not only must the U.S. be a party or have a direct and substantial interest, but the representation at issue must take place before a department, agency, court, court-martial, officer, or any civil, military, or naval commission. So department and agency are not defined in Section 203. So we need to look to 18 U.S.C. Section 6 for these definitions. And there you'll find that department means one of the executive departments enumerated in Title V. So again, we're looking at strictly federal departments. And agency includes only agencies of the United States. So that's going to include entities within the legislative branch and probably agencies within the judicial branch, although OLC has not expressly opined on that. But it does not include Congress or its committees. Additionally, OLC has determined in the context of an opinion on 18 U.S.C. 205 that it does not include state agencies or agencies of the District of Columbia. Now, the term court is not defined in Title 18 like agency or department is. However, in an unpublished OLC opinion from 1970, which is quoted in a 2000 public opinion, OLC has informally advised that the term court means any court, state or federal. But again, keep in mind that the U.S. must be a party or have a direct and substantial interest in the matter to implicate Section 203. So 203 is not normally going to be an issue in state court. Okay, so now that we've reviewed some of the elements that we're probably a little more familiar with, it's time to move on to compensation, which is going to take up the bulk of the presentation. And again, this is compensation in exchange for the provision of representational services at a time when the individual is an employee. So for Section 203 to apply, the activity must contemplate payment in some way. The employee does not actually have to accept or receive any compensation, as the statute also prohibits an employee from demanding, seeking, or agreeing to receive or accept compensation, again, when the other elements of Section 203 have been met. Further, the statute does not cover all payments to an employee, but only compensation that is in exchange for the provision of representational services to a third party, and again, when all the other elements have been met. So compensation could take a variety of forms. For example, it could be salary from an employer for providing these representational services. It could be hourly legal fees from a client. It could be a contingency fee for helping someone win a legal case against the government. Or perhaps it could be a commission for helping someone obtain a government contract or other business with the government. And again, these are just a few examples. However, compensation generally does not include reimbursement of expenses separately billed as actual costs. However, I just want to note that such arrangements should be considered carefully, and you want to encourage employees with these arrangements to discuss them with an ethics official. So moving on, one very important point to keep in mind about Section 203 is that it covers representational services provided by someone other than the employee personally. So the prohibition applies as long as the employee either directly or indirectly shares in the compensation for those services. So for example, an employee who shares in the overall profits of a law firm or a lobbying firm may violate 203, even if the individual does not personally accept the fees from a particular client for a representation. So for example, if an employee is a partner at a law firm, the employee may not share in any fees received by the partnership for representational work performed by the other firm members before the government. And this would include any kind of share in the profits of a firm engaged in providing such representational services. So on a related note, and before I move on to some examples, I'm bringing up the overview of Section 203 again. And I want to note that Section 203 has a separate payor offense for the person who would pay the improper compensation. So this provision has great practical significance because it potentially puts the clients or the business associates of an employee at risk as well. And so for this reason, many law firms are rightly careful to protect themselves and their clients by seeking advice from ethics officials before agreeing to a particular compensation arrangement for a lawyer who is or was a government employee. As a practical matter, employees should be aware that it may be necessary to make financial arrangements with a firm to expressly exclude any share of compensation that is prohibited by Section 203. Okay, moving on to slide 17. I'd now like to illustrate these concepts with a few examples. And because this is our first example, I'd like to go through each of the elements. And for the sake of illustrating some of these elements, I've made the employee in this example a current government employee. But don't let that throw you. It's only so I can illustrate certain other elements. Okay, so here we have Valerie, who's an employee at the Department of Energy. She maintains an outside law practice with two other partners. One partner represents a client before the IRS in connection with an investigation. She herself is not involved in this case and does no tax work, but instead works on real estate matters that do not involve the federal government. Her partnership share is calculated based on a percentage of the fees generated from all matters in which she or her partners are involved, including the IRS case. May she accept this partnership share? And because I can't see anyone nodding or shaking their heads, I'm going to have Cheryl help me out and stand in for our audience here. So we're going to go through each of the elements. So first, would accepting the compensation be other than in the proper discharge of her official duties?
Yes, presumably because she's engaging in this law practice, which is outside the scope of her official duties.
Exactly, it's her private practice. So then would she be accepting the compensation either directly or indirectly?
So if we're talking about the compensation that is tied to the representational services before the IRS, which I think is the compensation we're concerned about, right? It would appear, I would argue she's accepting it indirectly because she didn't provide those services, but she's getting compensation from other people having provided those services.
Exactly. Okay. So it would be indirectly because it's going from the client to the firm to Valerie in the form of her partnership share. We may have covered this already, but is the compensation in exchange for providing representational services?
Yes.
Yes. Does it matter that Valerie is not personally representing the client?
No.
Right. So the main point here is that 203 bars employees from accepting compensation for the provision of representational services either by the employee or by someone else. So if she accepts a partnership share based even in part on her partner's representation before the IRS, then she will be receiving compensation for representational services.
And I think that's the critical thing, and I think that's where where it can get tricky making determinations about whether or not 203 applies, is that compensation has to have been in consideration for the provision of representational services. And I think with law firms, that's obviously very clear, or any time where it's very clear that the very professional act is indisputably a representational one. But I think this is a place where it gets kind of, I think it can be a little tricky when you're dealing with something other than law firms and
or the employee personally providing the services.
Right.
So then is Valerie an officer or an employee at the time the services are being rendered?
It appears so, yes.
Yes. Does it concern a particular matter?
Yes.
Yes, it's an investigation, which is a particular matter involving specific parties. So then is the U.S. either a party or does it have a direct and substantial interest?
I think it has both. The IRS is a party and they clearly have a direct and substantial interest in an investigation.
That's correct. So then is the representation by the partner before a department, agency, or court?
Yes, it's before the IRS.
So in short, Section 203 would preclude Valerie from accepting the partnership share as described.
Now, the interesting thing here, though, is I guess I want to be a little punctilious here. It's not that she can't accept any partnership share. It's just she can't accept that partnership, that part of the partnership share that is attributable to, or that that was collected, or it is attributable to that representational service to the IRS. Is that correct?
Exactly.
Okay.
Exactly. Okay, so let's change up the facts a little bit. So what if she properly declines to take any share of the fees from the IRS case? But then her partners then offer her a larger than usual share of the fees expected to be paid by another client in the near future. Could she accept that?
Wow, that's that's clever. Do you want to walk through the elements, or do you want me to take a stab at what I think?
Just take a stab at what you think.
Okay, I would be inclined to say that the mechanism doesn't really matter through which they want to try to make her whole. The fact is that they would be remunerating her, even though technically it might be out of a separate pot of money, but they would basically be remunerating her for precisely the same amount that she's missing out on to share in the compensation that they received for that representational act.
Right. So the answer here is going to be no, because arrangements that are designed to circumvent Section 203 are not going to be permissible. So how can Valerie and her partners protect themselves from violating 203? The firm would need to maintain a bookkeeping system that segregates out any fees that Valerie would be prohibited from receiving under 203. And then she could take her partnership share, as Cheryl was saying, from those other non-prohibited fees. But she couldn't take her partnership share, again, from the prohibited fees. Now, what if Valerie were an associate or of counsel rather than a partner, and she received a salary rather than a partnership share? Would this arrangement be acceptable?
Okay, so she's not enjoying like a share of the overall profitability of the firm, which would have that representational compensation bundled in with it.
Right, and again, she only works on real estate matters. Those matters do not involve the federal government.
Yeah, so I would say that as long as her compensation, nothing about her compensation is in any way tied to those other partners or other associates representations that would be prohibited under the compensation that would be prohibited under 203, I think she's fine. It's just, it's all a matter of, is any of her compensation that she's receiving tainted, as it were?
Right. So the receipt of a set salary here would be a permissible means of avoiding the 203 prohibition. That being said, there's kind of a set of circumstances under which a set salary could be problematic. And this is explained in OGE's opinion 99x24. So a set salary could be problematic if the set salary had been agreed upon. There was some sort of mid-year salary increase based on an increase of the firm's profitability, and there wasn't any sort of deduction for receipts that would be prohibited under 203. So again, this is kind of a caveat to the proposition that a set salary is generally permissible. And we explain this in 99x24.
So the material thing in that, though, is that, again, the remuneration that she's receiving is somehow being tainted by being tied to other accounts, as it were, in the firm is receiving, that do entail representational services back to the government. So as long as the salary isn't in any way, or her remuneration isn't in any way tied or set according to something that is tied to those other prohibited compensatory arrangements.
Yes.
Okay.
Okay, so now moving on to another key feature of Section 203, as if 203 weren't complicated enough, now we're going to throw in timing. So as I mentioned earlier, compensation is prohibited when the representational services are rendered or to be rendered at a time when the individual is an officer or employee. However, if the representational services are rendered or to be rendered prior to entering government service, compensation is permissible. And similarly, if the services are rendered or to be rendered after the employee leaves government service, compensation is also permissible. So note that employment status does not matter under Section 203 with respect to the timing of the actual payment. So again, the takeaway here is that compensation is prohibited if the individual is an officer or an employee at the time the representational services were rendered.
So we're looking at when were the services provided. If the services were not provided while you were a government employee, then we're not concerned about the compensation.
Correct.
Okay.
So with the transition approaching and anticipation of many new employees coming on board, it's important to keep in mind that Section 203 has implications for a person who is entering federal government service. So on the prospective side, it is generally a crime for an individual to receive or agree to receive compensation, even prior to federal employment, if the compensation is in exchange for later representational services to be rendered when the individual becomes a government employee. So a special word is in order here about another important timing issue, and this involves contingency fee arrangements. So attorneys who are just entering the government from private practice sometimes arrive with a contingent interest in certain cases involving the government. And under a typical contingency fee arrangement, the attorney agrees to represent a client in exchange for a certain percentage of whatever amount, if anything, the client ultimately recovers. So here's the problem. The problem is that even if an attorney stops working personally on a contingency fee case upon entering the government, some other attorney is presumably going to have to pick up the ball and keep providing representational services, which will ostensibly occur during the employee's period of government service. And so the longstanding view of both OGE and the Department of Justice is that prior to assuming federal office, attorneys must find some way of disposing of all interest in contingency fee cases involving the government. And the reason for that is that the contingency fee, by its very nature, is compensation for all representational services provided in the case up until the point of payment, including those services provided by another attorney after the first attorney joins the government. So there are various options for disposing of a contingency fee interest. If you have an attorney who's entering government service. So these would include, oh no, I somehow managed to get rid of the slides.
Okay, hang on. Let's get us back in.
I apologize.
Nope, that's not going to do it. Hang on. Okay, hang on. Well, I don't know what happened. I think we may have just dropped the hang up.
While we're getting this up,
but if you want to go ahead and continue, just as if we're on, because I need to see where we are. Okay, you could go ahead and continue, and I will see what we're doing.
Okay, and again, I apologize for the technical problems. I think I may have clicked on something. So we were talking about contingency fee arrangements and how someone entering the government with one of these contingency fee arrangements in a case that involves the government, how they can dispose of that contingency fee interest. So one option that they have is to liquidate their share and convert it into a sum certain that is not contingent on the outcome of the matter. Additionally, under carefully limited circumstances, an employee may assign his or her interest in a contingency fee to another person, again, in a case in which the U.S. is a party or has a direct and substantial interest. And so OGE has an opinion on this at 99x20. We set forth the conditions for a permissible assignment of a contingency fee interest. And so what we say is that the assignment must be executed and effective prior to entering government service. It has to be complete, unconditional, and irrevocable. It must not be made to the employee's spouse, minor child, legal dependent, or household member. And it must not permit the employee's involvement after entering government service in determining the amount of the fee. And here we would say that consultation with OGE prior to the execution of the assignment is highly recommended. Okay, so we're going to look at another example, and we're still trying to get the example on the screen. In the meantime, I'm just going to read it to you. And for those of you who have printed out the slides, if you're following along, we're currently on slide 24. So in this example, we have Jacob, who's an attorney, and he's leaving his personal injury practice to join the Department of Justice. In his private practice, he has one Federal Tort Claims Act case against the VA. His retainer agreement calls for him to receive a 30% contingency fee, in addition to reimbursement for his litigation expenses if his client is successful. All depositions and other pretrial discovery and motions are concluded, but the settlement negotiations are ongoing with the possibility of a trial in the future. So may he hand this contingency fee case over to another attorney while reserving the right to a pro rata share of any contingency fees ultimately received. So just take a moment to think about that. But you might have a gut reaction already. And the answer here is no. Section 203 would bar this arrangement. Because as I described in the fact pattern, someone else would have to pick up where Jacob stopped. And that person would be performing representational services while Jacob works as a government employee. And if the plaintiff prevails, the contingency fee that would be due would be compensation for all the representational services provided in the course of the case, including those services provided by Jacob's successor attorney after Jacob enters government service. So moving on to slide 25, slightly different facts. May he assign his right to receive his share of the contingency fee to his spouse. And the answer here, Cheryl, if you'd like to hop in.
I would argue that no, you can't.
That's right. Assignment to a spouse would not be permissible. So slightly different fact, slide 26. May he settle on a specific non-contingent sum in lieu of a contingency fee prior to joining the government.
Now there I would say that it's kind of like almost like akin to, like as long as, it seems to me, yes, he could, because then it's not tied directly to the, like he's going to get it no matter what the outcome of the matter is, right?
Right, yeah. So this would be okay. And this is because he will no longer have an interest that depends on the outcome. It's going to be paid to him or due to him, regardless of whether the U.S. prevails.
Mm-hmm.
So while we're on the subject of contingency fees, I want to touch on three deceptively difficult little words, and those are in exchange for. Because of all the concepts here, I think this is probably the most complex and the least intuitive. And as I was looking at these three words, and as I was preparing for my discussion on this section, I realized that these three words could quickly swallow up the presentation because the concept is so nuanced. So all I want to say on this subject is again to reiterate that Section 203 targets compensation received in exchange for representational services. It does not, however, target compensation received because of or but for representational services. And the majority of the time when you see something that looks like compensation in exchange for representational services, that's exactly what it's going to be. So for example, hourly legal fees from a client, a contingency fee, and so forth. So I'm not going to discuss this slide, but I've included it here because I think it would be a useful reference. And I'd really encourage you to take a look at the advisories and the opinions that I've listed because they really discuss this subject in depth. And I think they'll be a very useful resource for you. So we just discussed the timing aspect for employees who are entering government service. Again, with the transition, there are going to be many employees who are not only entering government service, but who are leaving government service. And it's important to remember that Section 203 also has implications for them. Employees need to remember that once they've left, they're not off the hook. They still need to consider 203, especially if they're going to a law firm or another entity that is providing representational services. Again, it's a crime for an individual to receive compensation, again, after terminating federal employment, if the compensation is in exchange for representational services that were rendered while the individual was still in government. This is, of course, going to arise most often with attorneys who leave government and join private law firms, because firms sometimes compensate their members, especially their partners, on the basis of fees received for past representational services provided by the firm, including services that may have been rendered during the period when the former employee was still in government. So in these cases, the former government employee must make arrangements with the firm to avoid sharing in any prohibited compensation. Such arrangements might include, for example, agreeing to receive a fixed salary for a certain period of time. So moving on to slide 30, let's take a look at another example. So Jane left the Department of Health and Human Services to become part owner of Government Strategies, LLC, which is a government relations and consulting firm. While she was still in government, the firm began representing a coalition of state governments in their efforts to persuade HUD to modify its requirements for community development grants. Shortly after she joined the firm, the coalition paid its first bill for these services. May Jane share in the fees generated by the HUD work?
My reaction would be no, because the HUD work, those representations were taking place at the time that Jane was still an employee at the Department of Health and Human Services. And so she couldn't share in those fees.
Exactly. So this illustrates the post-employment effect of Section 203. Again, as Cheryl was saying, she may not share in the fees because they're in exchange for representational services rendered during the time when Jane was a government employee. So what if she were a salaried employee? Could she receive a bonus that was based on the firm's profitability for the calendar year in which those fees were received?
Well, I think again, and that kind of goes back to the other example we were talking about, is any monies that are tainted with, I use the word taint because I don't know a better word to use, that are tainted with compensation that even though the employee, him or herself, did not engage in the services for which that remuneration resulted, but any monies they receive simply can't touch any representational activities before the government that would have occurred while they were still a federal employee.
Right, and I think the use of tainted is a really good word. If the bonus was based on a percentage of the firm's profits, she would be receiving compensation for representational communications before HUD that occurred during her government service, and as such, it would be barred by Section 203. Again, it's tainted.
So again, it's a workaround for this, if you will, that would allow her to enjoy at least some bonus. Would be, they would just have to carve out of her bonus any amount that was attributable to those representational services.
Yeah.
Correct? Okay.
Yeah.
Mm-hmm.
Okay, so slight variation. May Jane share in any future fees for additional services that are rendered in connection with this matter? So this is after she's already left the government.
Oh, of course, because she's no longer a government employee, and we're only concerned about when those representations take place. And if these representations are now going to be when she's no longer a government employee, then the compensation is okay.
Exactly. So as long as the fees are for representational activities provided after Jane leaves the government.
These are some pretty advanced accounting practices these places have to have, is all I can say.
Okay, so moving on to the application of 203 to special government employees. So a special government employee, as you know, is an employee appointed to perform temporary duties for not more than 130 days in a year. Because SGEs almost always have other jobs outside the government, how Section 203 applies to them is going to be very important. So for Section 203, SGEs aren't as restricted as regular employees. Basically, if the SGE works for less than 60 days, then the restrictions in Section 203 only apply to party matters that they personally worked on. And then if the SGE works more than 60 days, the restrictions of Section 203 would apply to both party matters they personally worked on and any party matters that are pending at their agency. But Section 203 is not going to apply to all particular matters the way it does for regular employees.
So here's where that distinction between, and understanding the distinction between specific party matters and matters of general applicability, it comes into play.
Okay, so now we're on slide 34, and we're going to revisit one of our prior examples. So let me, do people generally see this on their screen?
Yeah, everybody should.
Oh, good. Okay,
yeah.
So I'm not going to read the example. But what would happen if Valerie, instead of being a regular employee, what if she were an SGE?
Okay, so she's not involved in the case. She does no tax work, but instead
just
works
does
on real estate. Okay, so if she were an SGE, you really have to tie it back to specific party matters that are pending before her agency, correct?
Right, so Section 203, again, only applies to SGEs in relation to particular matters involving specific parties, and then only if the SGE participated in the matter personally and substantially as a government employee, or if the matter is pending in the department or agency where the SGE serves, provided the SGE served there more than 60 days out of the preceding 365. So in this case...
Well, I think the critical thing there then is that if she works for the Department of Energy, she would only be 203 restricted with respect to things that were either before the Department of Energy or that she worked on personally, and or that she worked on personally substantially while she was at the Department of Energy, right?
Right, right.
And these are IRS matters, right?
These are IRS matters. So we can forget about the second condition because the IRS matter is not pending at Energy. Then regarding the first condition, it's highly unlikely that the Energy employee would have participated in this IRS matter. But we might want to check to make sure that Valerie didn't work at the IRS and on this matter before moving on to Energy. Okay, so slight variation. What if Valerie were an SGE at the IRS? So here, there's a little more cause for concern. And regarding the first condition, we'll need to find out if she worked on this matter as an IRS employee. Regarding the second condition, we know that the matter is pending before the IRS. So the question is going to be whether she served at the IRS for more than 60 days out of the preceding 365. So then if she worked on the matter or worked at the IRS for more than 60 days, then Section 203 would bar her from accepting, as part of her partnership share or otherwise, any fees for representational communications by her partners in the IRS case. And then I just want to wrap up by noting that Section 203 contains 3 exceptions, and all of these have similar counterparts in 18 U.S.C. 205. So that concludes our presentation on Section 203. I hope it was informative, and if you have any questions, I'd encourage you to contact your desk officers and or reach out to me as needed. Although please contact your desk officers first.
No, I think this, no, thank you, Monica, very much. And this was extraordinarily helpful, I think, to just walk through the statute and parse it, because it is a fairly complex statute, but it's also a fairly narrow statute in many ways.
Right.
And I think that one of the biggest takeaways from this is that, be mindful not to read it maybe too broadly and too restrictively, but also that, in instances where if you have something come up where you think you have a colorable 203 circumstance, because the fixes for them can be quite complicated, yes. It's definitely worth your while to touch base with your desk officer and contact OGE about it. Well, so thank you, everyone. Monica, I want to thank you very, very much. This has been a very helpful presentation. I'm sorry for the little glitch we had in the middle, but I think we ironed it out. So thank you all for joining us, and we look forward to seeing you next month for our next distance learning broadcast.
Thank you. At this time, the call is ended, and you may disconnect at this time.